Welcome to Planning for Protection.
Welcome to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about one of the biggest concerns families face as parents age, whether a nursing home can force the sale of the family home. Jeff, welcome back, sir.
Hello, Evan. It's good to be back.
Good to see you. Good to see you. Jeff, before families even start planning, what should they understand about how Indiana Medicaid rules treat a primary residence when someone needs nursing home care?
Well, very good question, Evan. Occasionally people come in and they tell me something to the effect, well, the nursing home told me we need to sell the house. And so that is generally not true. And so the reason that I say it's not true, the Indiana and maybe other states have a provision that if the house is held for sale or rent, then it can be considered an exempt resource for application purposes. And so the first thing that most people need to realize is if there is a community spouse still at home, say the husband is taken ill and is now in the nursing home, and the spouse is worried about can she keep the home? Absolutely. If she is still residing in the home, it is an exempt resource. But suppose the spouse has died and now the mother is in the nursing home. At that point, she doesn't have a community spouse to still live in the home, so we do have to do something with the house, and that is sign an agreement to put it up for sale or rent. And as long as that document is signed and submitted with the application, the residence is considered exempt for a period of time after the application is filed.
A lot of families hear that Medicaid takes your house, like you said, but what situations actually place a home at risk during or after the Medicaid process in Indiana?
Well, sometimes people say, Jeff, we just don't want to consider renting the house. It's too risky. We've had bad experiences with rentals in the past. The tenants tear it up. They treat it badly. They do drugs in it, whatever. And so they don't even want to think about rental. But if the house is already protected from estate recovery, then that's a consideration that we should talk in some depth about. Because the risk is, even if you rent the house during the pendency of the nursing home stay, the state of Indiana has a priority claim against the value of the assets that transfer in their estate after death. And if there's nothing done to protect the home, then you're sort of buying time, but you're still going to end up paying some money because the cost of nursing home care, of course, is quite significant even for Indiana. And there could be, depending on how long the person lives, a substantial claim existing at the time of death. So there is a balancing act to determine if, say, the spouse or say the person is in relatively fragile health and they don't think they're going to live very long, say less than 6 months, then maybe it makes sense to go ahead and rent it with the understanding that the claim will be relatively minor. And there is some things you can do to deal with those claims. So several thoughts to keep in mind. If there is the first thing, I guess, is that the Medicaid rate of reimbursement to a nursing home is significantly less than the private pay rate. And so right off the bat, you're getting a discount on what you would otherwise have paid. Number two, there is the income of the person is being utilized toward the cost of their care. And Medicaid is only paying the difference between what their income is and the reimbursement rate that they've agreed to with the nursing home. And so depending on how high their income is, it may not be that big of a gap that Medicaid is actually covering. A third thing to keep in mind is there's the ability to negotiate with the state of Indiana after death. And there are some discounts that can be obtained if you're able to provide a prompt cash settlement to the state. So all those things mitigate the otherwise the damages that a potential claim could create against the estate of the deceased person. But there are some things you can do to protect the home, and perhaps you want to talk about those, Evan.
Does it make a difference whether the person entering the nursing home is single, married, widowed, or still living with a spouse at home, Jeff?
Absolutely. As we discussed, if you got a spouse at home, they're going to be able to keep the home without any issue. If they are single, then you've got to make the choice. Do we sell it or rent it? And those are the factors that have to be considered.
Some people assume they should immediately transfer the house to their children or someone that they know in the family. What problems can that create if it's done without understanding the Medicaid look-back rules?
Very good question, Evan. Indiana has a 5-year look-back period, as do most other states, for any transfers. And if you do that within a 5-year period, I've had to undo those transfers many times because they didn't get their 5 years in. And so if you have made that transfer, especially of a house, within that 5-year period, you're not going to be eligible for nursing home services under the Medicaid program.
So Indiana families often have farmland, rental property, or property that has been the family for generations. What planning concerns tend to come up when the real estate carries both financial value and a little bit of emotional attachment as well?
I encourage people to think about doing what we call 5-year planning, where they make transfers and are able to stay out of the nursing home for at least a 5-year period after that transfer is made. And there's two main ways to protect real property in Indiana. Not every state has this, but Indiana does. So the first one is to transfer assets to an irrevocable asset protection trust. And I do a lot of those where people, especially with farmland or other significant emotionally charged real estate, like a home, will transfer that real estate to an irrevocable trust. And then they will, if they get past the 5-year look-back period, then it's protected and not subject to estate recovery by Medicaid. And a second way that people can protect real estate in Indiana is to transfer the property subject to a retained life estate. And so if you don't have a lot of financial assets and your only asset is really land or a residence, then you can transfer that to your children subject to a retained life estate. And under Indiana rules, at this time at least, that transfer makes the property not subject to estate recovery after the death of the recipient. And in those situations particularly, I recommend people consider renting it until the death of the person, because the property will not be subject to estate recovery when they die, and they will be able to receive a stepped-up basis in the property and sell it with no capital gains tax after the death of the applicant.
Indiana families may hear about, the tools like life estates, trust, or transfer on death deeds. What are these strategies designed to accomplish, Jeff? And how does someone know which approach fits their situation?
Well, the first two, irrevocable trusts and the life estate, do protect. Transfer on death deeds can slow down the state of Indiana's efforts, but they do not protect it, because Indiana has a provision that the state can pursue non-probate transfers, like a transfer on death deed, for reimbursement, even if it is a transfer on death deed. And so the risk is that the state will get better at estate recovery and pursue these non-probate transfers, and you'll end up that property will be subject to the state's claim anyway. So I don't recommend transfer on death deeds generally when you have the other options.
Timing seems to matter as well in a lot of these cases. What planning options are available if a family starts early versus waiting until the parent is already entering that nursing home?
Well, that's where that 5-year rule comes in. And so if you have time, it's generally a good idea to do that 5-year planning with either the life estate and or irrevocable asset protection trust.
Could you share an example, Jeff, of a situation where proper planning helped the family preserve a home or property that otherwise could have been exposed to unnecessary problems or expenses?
Oh, many, many, many examples. We've had people who have had property in a trust, and they end up going to long-term care, and then sometimes live a significant amount of time where the claim is going to be relatively large and huge, and the family is so grateful and thankful that the property is not going to be subject to that estate recovery.
And for someone listening right now who is worried about protecting the family home while also preparing for possible long-term care needs, what should they start reviewing now before a health crisis happens?
Well, this is obviously self-serving to say, but I think they should talk with a qualified elder law attorney who can give them their options and discuss the pros and the cons of all these options in a way that will allow them to protect those assets that they've worked so hard basically all their lives to accumulate and don't really want to see go to the government or the nursing home if they have a way to avoid that. In many cases, they do.
Thanks, Jeff. I appreciate you.
Thank you, Evan.
And that's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeff Ryder and his work at Jeffrey C. Ryder Attorney at Law, LLC, visit jryderlaw.com. Thank you so much for listening. And don't forget to like, subscribe to the show, and share this episode with someone who might find it helpful as well. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.